session on asset litigation. My name is Oluwatosin Isaac, and we'll continue from where we stopped the last time we were on air. The last time I was here, we talked about fundamental rights. That is what we were talking about. And if I should do a quick recap, we discussed an overview of fundamental rights, and we started with explaining the right to life, right to personal liberty, right to dignity of human persons. So today we are going to continue from where we stopped the last time, and we're just looking at a particular right today, which is the right to fair hearing. You must have heard of fair hearing. Everybody's entitled to fair hearing. Oh, I'm entitled to my right. Of course, we know your rights, but at the same time, for those that do not know, or for those that are not sure, or that might have questions, this session is for you to get you enlightened on your right to fair hearing. Now, I remember there was a time we did a session here where we talk about notions of court, that we corrected some notions about the court. And most people think that when you hear the courts, trouble. Hey, yeah, I'm going to take you to court, I'm going to do this. You start beating, you feel the court is a very bad place. Once they take you to court, that is the end of life. No. At the same time, when you get to court, I tell people that when you get to court, the court is just like, it's like you and somebody you are fighting, and there is somebody that wants to help you settle the matter. That is the way you should see court. So court is not like a death sentence. Most people see court as a death sentence. That once they take him out to court, that's the end. They will go into depression. The job you want court to. Sorry for those that do not understand Yoruba. I say, my case is in court, so hey, God don't allow us to see anything that will make us come to talk and start talking. I don't know, there's a way they don't say it in Yoruba like that. You understand? So most people think that when you come to court is the end of life. No. The court is, like I said, is like somebody that wants to hear both sides and state your own, and let the court decide. You understand? Just that the difference is now you are backing it up with the position of the law and some other judicial authorities that will help strengthen your case. So why do I refer back to that topic? Is because, like I said, the court is like a mediator that wants to hear both sides. So hearing both sides, that is fair hearing, when you have the opportunity to state your own side of the story. And as a lawyer, this doctrine has really helped me, even in my personal life and personal activities, being that when somebody tells me something about somebody, I don't really take it all in. Okay, fine, I say I've heard you, but I'm not going to judge the other person because the person is not there. I mean, whatever this person is saying to me now, there are elements, or there is every tendency that this person can be biased. If you say something that you want to gain my favor, but the other person is not here. So I just tend to, okay, fine, I just take it in, okay, I've had you, but at the same time, I'm not going to judge, or I'm not going to make any conclusion. Why? Because I've not had the other person's side. I mean, this person can be wrong, this person can be so biased, he might twist some facts, he might just say some things that will just make him gain favor in my side, you understand? So even in my personal endeavors and my personal relationship with people, I do apply the doctrine of fair hearing, because I know that everybody is entitled to be heard. I even saw I saw a tweet on Twitter. Most people are saying that the person tweeted it, and I can't remember what the person said. I can't remember what the person, like, word for word, but the person said something like, it's only the best student, that gets to say a speech on the valedictory service or something, that they should also give the person that came last, that he will have his own story too. I saw it, like, because most people tend to judge the best student as, oh, it's the most serious student, and like this, but the student that came last, or the worst student, the person is, people complain that he's unserious, he came like that. But suppose that in as much as the best student usually gets the opportunity to talk or give a speech, that the person that also came the last in the class should also be given the opportunity to say his own side of the story. Then somebody now made a post. He wrote a very short post on just that tweet, and he said that back when he was in school, when he be talking to his friends, that his friends will tell him that they can't attend class, they will have to go out, they are going out to look for daily bread or something, that we just laugh at them. And he said that then it wasn't really wise, because as a privileged child, it was opportune to have everything. I mean, the parents were providing, he had his school fees paid, there was money for food, feeding, clothing, a good accommodation. That was now, it was now that he has grown up, that he's now wiser, that he realized that most people don't have what he had, so they had to go and hustle. So while he had all the time to face his studies and read well, others don't. Some don't even have the proper place to lay their head at night. Some have to go out to just go and fend for themselves, to pay their school fees, and that way it can affect the output, the performance of such person. So it was in support that definitely even the student that came last, or the student that are behind, should also be given the opportunity to share their story. And people should not conclude that they were just unserious. Of course, there will be some reasons whereby some people, the reason why they fail is because they were unserious. But at the same time, that cannot be all the case. It cannot just we shouldn't give that general conclusion that it is because people are unserious, that's why they came behind in class. So that's just why I decided just to emphasize fair hearing. I mean, everybody should be given the opportunity to explain and say his or her own side of the story before coming to a conclusion. Everybody's entitled to fair hearing, and the doctrine of fair hearing was actually got from the Bible, in the story of Adam and Eve, where even though God, we know God is all-knowing, God is all-seeing, but yet he asked Adam, he questioned him, he questioned Eve, he wanted to hear your own side. Why did you do this? Asked Eve, why did you do this? You understand? So that is the doctrine of fair hearing, natural justice, that every party should be heard before judgment or before the conclusion is reached. So I have the Constitution here with me. The Constitution, this is the Constitution, a hard copy of the Constitution, and the Constitution is the one that guarantees the fundamental rights of a Nigerian citizen. So I said last week that the rights, the fundamental rights, are contained in Chapter 4 of the Constitution. However, in Chapter 4, the right to fair hearing is provided for in Section 36. So the whole of Section 36 is provided for fair hearing. So if you are looking for, oh, what is my right? What does the Constitution say about my right to fair hearing? You can go to Section 36 of the 1999 Constitution, and you will get all that you're looking for right there. So I'm going to be making reference to the Constitution. I mean, pardon me, but I'll just be reading some things from the Constitution, and we are just going to be, I'll be elaborating on it to make you understand what each clause or what each section talks about, so you can be fully aware and enlightened of your right to fair hearing. So when you hear court, or where there's a dispute and the conclusion is reached and they just had one side of the story, then there is there's elements of injustice. You can't come to a conclusion without hearing both sides or all the sides, as the case may be. So I said Section 36 of the National Constitution, as amended, provides for your right to fair hearing, and in sub 1 is saying that in the determination of every person's civil rights obligation, where it comes to his rights, civil rights obligation, any question, whatever the case may be, that's what that place is saying. Every person is entitled to a fair hearing within a reasonable time by the court or any tribunal established by the law. So everybody, regardless of the case, that's what it's saying. Civil rights obligation, you have questions, you need clarifications, you have suits, whatever it may be, in a court of law within a reasonable time, everybody is entitled to fair hearing for it to be addressed. So whoever is in charge, whoever the party may be, even if it's government authorities, okay, so we have seen cases where an individual is suing the government, even if it's the government, even if it's regardless of who the person is, the law is no respecter of anybody, nobody is above the law. Every party must be heard. So another section is saying that such proceedings should take place in public. Yes, the proceeding of a court or proceeding of any tribunal related to the matters mentioned in subsection 1, including announcement of a decision of the court or tribunal, shall be held in public. It's a public court. It's a public court. So whatever proceedings you want to hold, where you want to exercise your right to fair hearing, must not be in private but in public. However, to every general law there is usually an exception. So an exception to this is the fact that a person that is charged with a criminal offense, and it might never be criminal offense now. If you are before the court and you want to be heard, it should be in public. However, there are cases whereby some cases are not held in public, where it is only the parties that will be there with the judge. Other parties, the public, even there are some cases even their lawyers are not even allowed. You understand? Like for example, we have family cases where the case between the wife and the husband, it is usually held in the judge's chamber. It's not a public case. The court does not come and sit in the public, and the husband is here, the wife is here, and there is back and forth. No, it's always public. So both parties are invited into the judge's chamber, and the judge hears them in private. So that's it. Then if it has to do with the welfare of a child, also a child has not attained the age of 18 years, that also can be held in private. And when it has to do with matters, affairs of the government that is not being in the public interest, it should not be discussed. There are some topics, there are some sensitive topics that cannot be addressed or discussed in the public. Of course, such proceedings will take place in private. So another section provides that every person that is charged with a criminal offense shall be presumed innocent until proven guilty. Very, very important. So in fact, even if you catch somebody red-handed like this, before the law, the person is still innocent until you are able to prove before the court that this person is guilty of the crime. Because when some people are committing crime like that, probably they may not be mentally sane. They are not in their right senses. That's the difference. So that's why even if you catch somebody committing a crime red-handed, like, hey, I've caught you, I saw you, you will still need to prove to the court that truly this person committed the crime. So another rule of fair hearing is that anybody charged with a criminal offense is presumed innocent until proven guilty. So any person charged with a criminal offense shall be entitled to be informed. Yes, you don't charge somebody and you don't tell him what he's being charged for. When the suspect is being arraigned before the court. I think we're going to talk about arraignment very soon. When the suspect is being arraigned before the court and he has been charged, his charge has been drafted, you so and so on the dash day of this at so time committed an offense, blah blah blah, contrary to section this of the criminal code, you understand? So the charge has been drawn and written. However, before you go ahead and say, okay, you're also going to try or something, you must read the charge to the person and ask the person, do you understand what you are being charged for? So if the person say no, they'll come again, they'll read it again. Until the person say yes, I understand. You understand? So it must be in the language the person understands details of the nature of the offense. This is what you did at so time, at so time, at so time, in so place. You understand? Okay, you committed so crime at so time in this local government, in this location, at this time, contrary to section this of the criminal code. Are you guilty or not? I'm guilty, I'm not guilty. So that's it. So the person must be properly informed of the nature of the offense in detail in the language he or she understand. So of course also the person must be given adequate time and facilities to prepare for his defense. There are some cases, even if you plead you are guilty, you'll be advised to take a lawyer to defend you. Cases like capital offenses, like murder, armed robbery. Even if you say, okay, fine, I am guilty for a murder case, the court and you say, okay, I'm guilty, just charge me to. No, it's not like that. You have to prove that truly you committed that offense. So you will still go to trial like that. So you have to get enough time to prepare for your defense. You can defend yourself in person or by legal practitioners. Okay, fine, but there's an exception. There are some cases you cannot defend yourself. You have to get a lawyer. It's advisable you get a lawyer because there are some practices of the court, procedures of the court you might not be familiar with, or you might not know. It's not known to you. It's only known to lawyers. So it's always advisable that if you have a court case, you get a lawyer, unless maybe you are very, very sound with the knowledge of the law, the procedures of the court, and how to go about it. So another subsection is that if a suspect does not understand the language, he is entitled to an interpreter. Yes, even without payment. We've seen this so many times in courts where the suspect does not understand English and there is an interpreter standing close by. Okay, you understand Yoruba, fine. Whatever it is the lawyer says will be interpreted. Whatever word is coming out from the bench will be interpreted to him. Whatever the judge says, it will be interpreted. Whatever the lawyers are saying, it will be interpreted to him. He must be aware of what is going on because he is being charged for a crime, and if he is found guilty, he is going to be convicted. So he needs to understand what is going on. So another section says that when any person is tried for a criminal offense, the court or tribunal shall keep a record of the proceeding, and the accused person or any person authorized by him in that behalf shall be entitled to obtain copies of the judgment in the case within 7 days of the conclusion of the case. What this is saying is that there are records of the court from the inception of when a case is brought before the court, from the day it was mentioned even to the end when judgment is given. The court has its record. What happens also day, okay, on so day this is what happened. And if you need a copy, okay, let's say for instance you came late to court. And your case has been called. When you arrive at the court, the court is already in case number 20, and your case was like number 10. So it means you've missed your chance. So you don't know what actually happened. You were not in court, but the other lawyer was in court, and unfortunately you never recognize the lawyer, or probably you know him, but you did not meet him in court. How are you going to know what happened that day in court? I mean, you need to give your client a feedback of what's happened. You are there to represent your clients. You came late, which is very, very improper, by the way. But you came late and you did not know what happened. You were unable to get the other lawyer to the other party to tell you what happened. What will you do? You apply to get the record of proceedings for that day. Yes, there's something called record of proceeding. So you can apply for the CTC, get a copy to know it. So there is usually a record of proceeding that it's in court. So if you want to know what is going on, you are entitled to it. All you need to do is just apply and pay the necessary fees, and you get one. So the person that is tried for an offense, his lawyer can apply on his behalf to know the proceedings of what happened. Though it will actually be in court though, but if he wants a copy, you apply. So another clause under fair hearing is no person shall be held to be guilty of a criminal offense on account of any act or omission that did not, at the time it took place, constitute an offense, and no penalty shall be imposed for any criminal offense heavier than the penalty in force at the time the offense was committed. What does this clause mean? This clause means that if a person commits an offense, but as at the time he was committing it, it was not an offense. Let me use an example. There was a time lesbianism, being gay was not an offense, but now it's not an offense, right? 14 years imprisonment. But there was a time it was not in a written law. It was not a written law. It was not written. There was nothing like that. You get? So if before it was enacted into law, people have been, Mr. A and Mr. B are gay. Let's say the law was enacted last year. Mr. A and Mr. B have been gay since 2010. Now, they've been gay since 2010, so it's not a written law, so it's not an offense. They've been gay. But it was not enacted into law last year. You cannot actually charge them for that offense. Now that it has been enacted as a written law, so it's not an offense. But at the time they became gay, it was not an offense. So from that 2010 to last year, when it was not enacted, it was not an offense. So they cannot be charged for gayism and be in prison for 14 years. So if you want to charge them to court, if after you've enacted it as a law and you said, okay, being gay is an offense, and from that time they still come out openly and say we are gay, okay, then you'll be charged to court. I don't know if you understand. Or let me use the example of somebody, let's say I'm giving an offense. Let's say I'm looking for a very practical example so that you can understand what I am saying. Let's say to enter into a boutique, for instance. Okay, you tell somebody that this cloth that I'm seeing in this window, I feel like stealing it. You have a motive to steal. You've not stolen it yet, right? But you have a motive. You are cooking up something in your mind. Like, now there's no written law that says that if you are just looking at something and you're thinking of saying it is an offense. There's no law like that. You've not attempted to. You're just looking at it and something is telling you that God, I just see this thing and run away. You understand? So it is not an offense. But if tomorrow the government says mere looking at something and thinking of it, thinking to do it is an offense, you've done it. You've at a point in time done it. You've thought of it. You're like, I should just steal this. I should just steal this fine shoe, this fine dress. And the government comes tomorrow and say, if you think of something like that, you say you want to do something, you want to commit a crime, even if you did not do it, but mere thinking of it is a crime. The fact that you've done it before does not mean that you will not be charged, because at the time when you did it, it was not an offense. But if you do it again after the law has been written and enacted, then it becomes an offense. So what this section is saying is that no person, you cannot try a person because you have committed that crime. Come and take the punishment. It's called retrospective legislation. The Constitution is against it. As at a particular time, it was not an offense. Now you've made it an offense. So it means even though somebody has committed it, then when he did it, it was not an offense. But because you've enacted a law that termed it an offense, you cannot say because the person has committed it, it should now be brought. You remember 2010, you did this. CO in 2022 is not an offense. Go and bring him and let him come answer for his crime. No. So that's what Section 8 is saying. That no person shall be held to be guilty of a criminal offense on account of any act or omission that did not, at the time it took place, constitute an offense. So as at the time when it happened, it did not constitute an offense. So you cannot actually be held him guilty or impose a penalty on him. So that's that. So let's go to Section 9. Section 9 says no person who shows that he has been tried by any court of competent jurisdiction or tribunal for a criminal offense and either committed an offense and gave it tried for that offense or for a criminal offense having the same ingredient as that offense, save upon the order of the Supreme Court. You know one reason why most people say lawyers they don't always understand the law, or when they carry the law, they don't understand that the grammar is too much, blah 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 blah. I understand. So that's how I'm going to break it down to layman terms to explain what Section 9 is talking about. Section 9 is saying that if somebody committed an offense, somebody stole, and the court has already tried him. He stole, now listen, he stole Nike's 50,000 naira on so day, at so time, in so location. That is the fact, that is the ingredient of the crime. He was tried for stealing Nike's 50,000 naira at so time, in so place, at so location. Now, if he has been tried, if the court found him guilty, he will be convicted. If the court did not find him guilty, he will be acquitted, right? So whether he was convicted or acquitted, you cannot come back again to the court and say, I want to try him again for stealing Nike's 50,000 naira, the same location, same time, same place. So you cannot bring a case that somebody has been charged for is either he has been convicted or the court set him free for that particular offense. You cannot come back and say that you want to try him for that same offense. Okay, the court acquitted him for stealing Nike's 50,000. The court did not find him guilty. And I'm bringing another case and say, okay, this time around it is Shola's 100,000 naira. Now you see it's different. Yes, it's a case of stealing, but this time around it's not the same ingredients as the first one. Now this one is Shola's 100,000 naira. Maybe same place, same time, but now it's Shola. So of course it can be tried. But you cannot say, oh, the court has already freed him. The court has freed him. The court did not find him guilty of stealing Nike's 50,000 naira. But you, because you are still paid, you now carry him to another court again. I said because this court did not, you are not satisfied with the judgment. The court has acquitted him, but you say no. You now say you want to sue him. Maybe you just say maybe after 6 months, maybe the court would have forgotten or something like that, or the court not remember. Then you take it to another court again and now sue him for the same ingredients. The ingredients of emphasis on the ingredients now. The ingredients of the crime, the same. If it's the same, you cannot do that. That is against the right to fair hearing. If you are not pleased with the decision of the court, you can simply appeal to a higher court. Not that you will now go and say, hey, you want to charge him again. No, it's not. It doesn't work. Same thing with someone that has been pardoned. So either the person was pardoned, he was convicted, or he was acquitted, he was set free. The court does not hold him for that offense again. So you cannot bring the case again before another competent court to try him for that same ingredient. So that's what section 9 and section 10 is saying. So section 11 is saying that no person who is tried for a criminal offense shall be compelled to give evidence at trial. Anybody that wants to give evidence will give evidence. If the person says he cannot give evidence, the person that is being tried, that's the suspect. If he says he doesn't want to give evidence, you cannot compel him to give evidence. So the last section 12, is saying that you cannot convict somebody for an offense that is not contained or prescribed in a written law. If it's not in the law, you cannot convict such person. If thinking of committing a crime is not in the law, it is not stated anywhere in the law that it is a crime, you cannot bring that person and convict that person. On what ground? What section are you going to use? What law are you going to use to back up your position? You understand? So that's what I said. I've explained it earlier on, that a written law, now we are talking about maybe an act of assembly, the act of National Assembly, or the law of a state, or a subsidiary legislation. So if the offense is not contained in a written law, you cannot convict a person of that offense. It means it is not even an offense because the offense is not defined. It's not defined in the law. There is no penalty stated. So what are you charging the person for? It's not an offense under the law. So that is that. So that brings us to the end of this week's session on fair hearing. I hope I've been able to enlighten you and shed more light on it. So maybe when you carry the Constitution next time and you're reading it, you will understand. You will understand better. Don't get confused with you safe to accept there upon daring. don't get confused. It's very, very